And now I am here with Kim Silvers. She is the president of Silvers HR, the owner of the company. And she brings 20 plus years of HR experience in the private and public sector. She's a certified senior professional in HR at the national and state level, award-winning public speaker. I've spoken with her, and I can attest to her ability to speak, especially on stage. Now we're going to test her out on the show here for Haney Biz again. And let's see, 2017 Athena Award winner, Wise Women Outstanding Women Leader Award, Silvers HR recognized as SAC Business Journal's fastest growing companies list. Wow. I'm honored to have you on the show, Kim. Thank you for joining me.
Thanks, Mark. It's fun to be here.
Yes. Okay, so we're going to talk about a few things related to HR that I think are some of the more pressing issues, and then maybe if there's time, we'll give sort of like some common sense stuff. You'll bring the C student, Mark Haney, up to speed on really how to be an employer. So let's talk about that. I think the first thing that I wanted to, I guess, dive into a little bit is something called AB-5, right? This is this regulation that seems to be scaring folks that are involved in hiring people in the gig economy and using subcontractors. Can you sort of elaborate on the scariness of that?
So AB-5, which was just signed by Governor Newsom this year and goes into effect on January 1st, 2020, was the outcome of a court case that was rendered, I think, about a year and a half ago called Dynamex. And in essence, AB-5 pretty much eliminates the possibility of having an independent contractor working in your business, unless they meet some very specific criteria. So businesses, small or large, but in many cases, small businesses start out with contractors rather than hiring employees. It's very expensive to have an employee. And so they'll hire contractors and pay them either an hourly rate or a piece rate or something to finish the job. AB-5 says that everybody is an employee unless they meet this criteria.
Okay.
And so therein begins a lot of weeping and gnashing of teeth of it is just going to cost us a whole lot more to have employees and take more risk with employees.
Well, I want to dive into the testing associated with it. Is he or she a contractor, or can they be, or do they have to be an actual employee? But I want to think about like the cost that this causes us as employers. So if I'm using a subcontractor, typically I'm avoiding things like some of these wage and hours laws. I'm avoiding workers' comp, potentially benefits of some kind. Why is everybody so up in arms about this?
Well, certainly if I have an employee, I'm paying the other half of the FICA match, the Social Security match. I'm paying for workers' compensation insurance. I'm probably paying for some sort of health insurance if I have any sizable number of employees. All of the employment laws, federal and state, apply to me eventually, depending on my size. But it means that employees certainly have more rights, and as a result, I have more exposure as the employer to be sued or to go to the labor commissioner. All of those laws.
So the risks go way up when you bring on the employee.
Right.
Okay.
Yeah.
So those risks, those real costs as well, are really putting the entrepreneur that's I guess on the cusp of profitability or survival. It's putting them in jeopardy of actually going out of business in some cases.
Yes, and I think for many, particularly new businesses, they feel like they need the flexibility. I'll hire a contractor, I'll pay them by the hour, which, by the way, is risky anyway, and I'll call them in as I need them. As we have the business, I'll use them. And some people think if I have an employee, I have to guarantee them number of hours, I have to give them vacation and benefits and that. And, until you get to 50 FTEs, you don't have to give them group health insurance, but you do have to give them paid sick leave. Certainly, many employees are going to say, hey, I want holidays, the same as they get down the street at Placer County. and I expect that you'll give me vacation. And so although all those things except paid sick leave aren't required, employers start to feel like I owe these people a set schedule, I owe them some recurring revenue or income, and I owe them benefits. And, eventually you end up with 35 to 50% markup on hourly wage because you're paying all those.
Wow. Okay, who's most affected by this? Is it early stage companies, or are you seeing people that have a sales force of outside independent contractors that are like, I have to switch all my contractors over to employees?
I think probably the biggest group who are affected by this right now are the delivery drivers and the car services, Uber, Lyft, DoorDash. And in fact, those three companies have set up what I'm told is a $90 million campaign to get something on the ballot in California next year to at least exempt them.
To go ahead and fight it for them personally, but it doesn't fight it for everybody else. It fights it for an Uber driver.
Yes.
What about real estate agents?
So real estate agents are interesting. So they are one of the categories that AB-5 says there are some exemptions to what's called the ABC list to determine if somebody could be an independent contractor. However, in almost every case on these exemptions, and there's a laundry list of exemptions by occupation as well as by industry, if they don't have to pass the ABC test, they have to pass what's called the Borello test, which is another old case that the court came back and said if people don't hit this criteria, then they will be considered employees. So you can do a short ABC, 3 questions, and make that determination. But if you're exempt, you have a list, and I want to say it's about a dozen criteria.
Well, I want to get into this list, but these exemptions, are these driven by lobbying groups and things like that have driven for the exemptions? So the real estate lobbyists have carved out real estate agents?
Totally.
Okay.
Insurance sales. At the last minute, manicurists were added. So I have no idea that manicurists have a big lobby. But yes, they just they kept adding on right up to the last minute on the exemptions for this.
Crazy. Okay, so let's go through the list. So you've got the Borella, and then you've got the ABC list. The most recent one is the ABC.
Yes.
Okay, so maybe we talk about that. Sounds simpler than Borella. That sounds scary.
Yeah.
Okay, let's start with the ABC. These are the things that you need to do if you want to have the choices that you go through when you decide whether you actually have an employee or you have a subcontractor.
So the way AB-5 reads is everyone's an employee. I'm not quoting exactly.
Okay.
Everyone's an employee unless they meet all of these 3 criteria, A, B, and C. So the first one is that how much control the employer has over that individual. If the employer is saying, here's when you report to work, here's where you report to work, here's what you dress, here's your business card, here's how you do the work, that looks more and more like an employee. So control is the first criteria.
Can I dive into the control piece a little bit? You said looks, acts, and walks like an employee, and are there ways to sort of circumvent the? You talked about business cards. What if on the business card it says outside consultant and maybe an email address that is not the normal email address? Are there ways to sort of work around?
Well, certainly on those things, you could call them out specifically and say, you're a representative of as outside party. But it really comes down to how much control and direction is the company giving that individual.
And it's the actual behavior. So if you had a contract that said, I will not do this, I will not do that, that contract is not really enforceable if you are actually requiring them to be there at 8:00 for the Monday morning sales meeting.
Right. It's practice, not policy, that really carries more weight.
Okay.
So that's
control.
the A.
Okay.
B, which is probably the most concerning to me, is the employee or the individual doing things that are core to the business. If I'm doing things that the business is in business to offer to give their clients, then I'm not a contractor. I'm an employee under the law. And then the third
Can I dive into that one a
Sure,
little bit? Because
yeah.
I want to, let's say there's a company that has, so you are an outsourced HR person, and I have an HR person in-house, and I subcontract out to an HR person as a subcontractor. That's legal if they're a real company, but if they're a person that didn't have their own business, it's not. I mean, how could you do an outsource on human resources?
The good news is easily.
Okay.
Because, for example, in Haney Biz, you are not in the business to offer HR services.
Oh, gotcha.
So under the B criteria, I'm not doing work that is core to your business.
Okay, that's like a support function, if you will. Okay, so
Yes.
support functions are deemed okay to sub out or use a subcontractor for. But things like if I'm in the business of putting on a podcast and I brought somebody in here to help me with my podcast, that could be a no-no, a gray area.
It could be.
Yes.
And keep, oh, by the way, HR consultants are part of the exempt criteria because we have a really big lobby as well. But the C of those three criteria, and by the way, they have to meet all three of these to be considered an independent contractor. So C is, does that individual have a regular business where they're servicing more than just one client?
Okay.
And it's an ongoing sort of business.
That's helpful. So if I had, let's say I was having somebody help me with my newsletter and they were a professional writer and they wrote for all kinds of people and they helped me, type up my newsletter or something. That's okay.
Yes.
Okay.
Yes.
Got it. Okay. So I'm going to sort of repeat it back. Because ABC, but A stands for control. Okay. This is a little confusing for me. So A is the control. B is the what again? I'm sorry.
Core to your business.
Core to your business, right? Core to to what you sell, what you do for your business. And then the C is?
The C is that person an ongoing business entity?
Okay, so they do business with other people, other customers. Which of these three do you feel like is like the most problematic?
Well, I think, and again, you have to hit all three in order to cross the line. But I certainly think doing things that are core to the business, it is just so hard. And again, when you're a startup company, you need to have people who can help you deliver and bring in revenue and do what you're in the business to do. So that's really the difficult one to cross.
So somebody like the commission salesperson, that's the one that kind of jumps out at me. Is so if I'm out here selling a widget and I need to bring on somebody sort of part-time to help me, so I'm just going to pay them on the side I'll 1099 them. They've got their own little, they may have their own consulting company, but if I'm their only customer that they're doing sales for, they're actually working on my stuff.
It could be problematic. Outside salespeople also have an exemption.
Oh, they do?
Yes.
Okay.
So, and what the law says is if you're in these exempt categories, then you don't have to meet the ABC test, but you also have to review under the Borrello criteria to see if you still can be an employee or an independent contractor.
And the law goes into effect. It's something that's recent. And does it go into effect on January 1 or is it already in effect today?
Well, the case law has been in effect for a year and a half. So, it's in effect. Mm-hmm. But the actual AB-5 goes into effect January 1st.
Okay, so it becomes more crystal clear. And what do you expect to happen? Okay, so I haven't seen the lawsuits going. I haven't seen the all these claims happen yet. I haven't been hearing about them. I don't know if you are yet. But what can we expect if this for all the people that don't adhere to the policy?
Well, I think, quite frankly, and there are lots of lawsuits, most of them are driven either by the IRS on the federal level or the California Employment Development Department to say, you should have been paying taxes on that person. And so they will look at, was that person a W-2 employee, and then you converted them doing the same work to an independent contractor? That's a no-no.
Okay, that's kind of obvious, though, right? If you can see that someone's intentionally trying to, get out of paying certain things, that seems like an obvious one. But the one that's, hey, this guy's been a 1099 forever, and they didn't change.
Right, and so people who are doing work that you have employees doing. So quite often I'll have somebody call me and say, I really want to hire this guy, but he doesn't want to be an employee. He just wants to be a contractor. So can I just make him an employee and or make him a contractor and everybody else an employee? That is a big red flag for the IRS and EDD to say he doesn't get to pick. It's not a vote. It's not, majority wins.
I've had that happen many times too, and it's tempting, kind of, especially as somebody trying to survive. Look, I'm an early stage company. Things are not really rolling yet. Look, don't we cut corners at the beginning a little bit and just try to hunker down and make sure that you don't go out of business? I mean, how do people wrestle with that?
Well, certainly there's nothing illegal about hiring temporary employees, intermittent employees, part-time employees. So you set the schedule for them. Is it going to cost you more? Likely. Usually independent contractors earn more than employees do because they're paying both sides of their FICA. They're buying their own benefits and that sort of thing. So, in the early days, I had an independent contractor. Now, this is a long time ago, but, I was doing part of the work. She was doing part of the work. And every year, I would come to her and say, I need to pay you less. You're going to make more overall, but, our expenses are starting to go up. And eventually, I converted her to an employee. But, it is expensive, and so I converted her to a part-time employee, and she worked when we had work, and I paid unemployment insurance, and I paid workers' compensation insurance, and I paid the FICA match, and so she earned less. But, I just felt like she's representing me now in my company. So in the early days, employers may say, I'm going to take that risk, and, I'm going to hire contractors, and I'll write a vendor contract with their company. They'll have a federal EIN, and I'll just take the risk.
Yeah.
So, that's what business is about.
So covering your butt a little bit, I'm not saying that you would recommend that they do anything that was not according to the law. But, okay, so you are doing things according to the law. The documentation of that in the form of a contract, is that, I assume that's recommended?
It certainly is recommended. And it's something that, you don't want to have something called an independent contractor contract. You want to call it a vendor contract.
Vendor contract.
Vendor, right?
Oh.
And you want legal counsel to review that. You just have so much exposure. Now, there was a California law that was passed now, probably 8 years ago, that said, in essence, only attorneys can advise someone to have an independent contractor. I am not an attorney. So people call me and say, don't you think I could make this guy an IC? And I say, I can tell you I think he should be an employee, but I cannot advise you that somebody should be a contractor, or I take personal liability with that. So I think if you take that risk, you do it under advisement of counsel.
Okay. So I call you and you just say, call an attorney. Maybe you probably have attorneys that you just refer out that are kind of up to speed on this kind of stuff.
Sure.
Okay, so have a contract is a good idea, though. You're not going to advise us, right? You're not an attorney, so okay. But I have to assume that it's a good idea to document. Well, I'm thinking generally too. Maybe I'm going to kind of derail off of this independent contractor thing. It's a good idea to document things generally. Is that true, or is it better not to document? Because once it's documented, it's like good or bad. It's in the history. It's in the files.
Well, sometimes even if you think you're not documenting, the other person is documenting, and making their memos for the records. So I always advise that, whether it's accountabilities for an employee, accountabilities for a vendor that you hire or another company, what are the deliverables? I always advise that you get those in writing early on.
Okay, so I'm going to dive into this documentation thing a little bit because it's interesting to me, because if if it's not written down, then in many reasons it doesn't happen, right? So some problem happens down the road with an employee, they come back, and if it's not in the file, you're going off memory, and it almost feels like hearsay if you actually have a claim. Is it important to document good and bad behavior? I mean, because you can't document everything. What do what do you document so that, when there is a claim, hey, that guy, wasn't showing up for work on time, or that guy or girl, right? It did something that wasn't according to policy. Should you always document that?
Well, you could spend your whole day documenting every conversation, right? And sending yourself emails and making notes. We have a form we just call a memo for the record, and it's for good and bad things. And I don't use it in case somebody gets in trouble. I use it mostly because we do annual performance appraisals. And, Mark, I can remember about 6 weeks back. And I remember the real peaks of the year, and I remember some valleys. But, as we just kind of roll along, I don't remember those things. And so I'll just, we got a compliment today from this client or whatever. And that's just helpful for me to go back and look at it. And sometimes there are way too many valleys. And so I start to look at that pattern as well.
Are there do's and don'ts in terms of that documentation? Because I've seen performance appraisals that went on and on about this guy is always this and never that, and just raving one way or the other. And typically people aren't always one way or never the other way. And people want to say something emotionally charging, whether it could be good or bad, in the documentation at times. Not everybody does that, but I see that. I've seen that with my employees, with my supervisors, and so on. It's like, you can't really document it that way, or we're going to be hung out to dry if there's a problem.
Mark, you talk like someone who might be married to someone in HR.
My wife, yes. As for those of you who didn't know, my wife Stacy was HR director for the city of Roseville, and so I had a little side coaching as an employer with hundreds of employees and many new supervisors, right, from video stores to a security camera company with hundreds of employees. It's like employee regulations and law was something I sort of grew up in. And my parents had a TV shop when I was a kid, so we were always, I guess, somewhat aware of, having employees comes with great responsibility.
Yes. I think the documentation, particularly on performance appraisals, is and I've adjusted my performance appraisals that I do for my team to say, we have some key competencies I want them to focus on, and do more of this, do less of this. And, or sometimes it's keep doing this. And so, I just kind of call out those things. They don't go on and on and on for pages. And, quite frankly, yes, the more I write, the more that can and will be used against me. I think we've all inherited some employee who either had no documentation or had only positive documentation. In the first 2 weeks, you're thinking, oh my God, how did this person last here? Well, the last 2 guys were scared to death to put anything in writing because they might get sued. So they haven't done anything. And then you're starting from ground zero. So I feel like my employees deserve to have feedback. I take it seriously, and I think a long time about what I'm going to put in writing. But that's real feedback for them.
I had something called an ABC rule for my documentation. The ABCs of documentation. It needs to be accurate, it needs to be behavioral, and it needs to be consistent overall. So I don't know if that's something that's still applied. That's something I remember from my days as being a manager.
I love that.
Okay.
And I think, D might be, don't put your personal thoughts in there. I think you're late for work because you're messing around with your boyfriend.
Yeah.
I think you're lying. Those sorts of things, even in memos for the record, can be really embarrassing in court. Yeah. So, just the facts, ma'am. And
what about those people that keep the side HR file, right? So, hey, I got these files in my desk. These are my little notes in case I need to bring them out. But when someone goes to court, those things can be subpoenaed. Am I right?
Absolutely. There is no such thing as a confidential or secret file. It's all discoverable.
Wow. Okay. So I'm having flashbacks. I'm not dealing with that as much today. We have companies that have employees. We're, I think, at 25 employees. Are there certain thresholds where, hey, it's better to stay under 50 employees or 25 where things kind of trigger?
Well, I think at 50 employees, it becomes much more complicated because the Family Medical Leave Act and the California Family Rights Act kick in. And so those are big leaves of absence that require lots of documentation. I mean, we have the templates and the form letters and the checklists for all of that, but it's tedious work, and they're protected leave, and you have to hold somebody's job open or for up to 12 weeks. So I often say to young companies, when you get to employee number 49, I want you to call me and let's think about whether hiring employee number 50 is really the direction you want to go. Can you leverage what else it will take to manage that because of the additional laws compared to what you're going to make in revenue?
Well, you mentioned Family Leave Act. Can you describe what that is?
So the Family Medical Leave Act is a federal law. There's a California version of that called the California Family Rights Act. And in essence, it allows employees who've been employed for at least a year and work 1,250 hours to take up to 12 weeks off in a 12-month period to care for a family member for their own illness or injury and or baby bonding. There's also additional time if they're taking care of a family member who has an injury due to war service or that sort of thing. So it can be up to 12 weeks. When you put pregnancy on top of that in California, it can be up to 7 months of protected time. It's unpaid, but you must guarantee that person the same or similar job when they return.
Okay, so what about if you have a salary exempt employee that needs to take their 6 weeks off for family time? If they say, hey, it's for this family medical stuff, you still don't have to pay them even though they're a salaried exempt employee? Or in that case, hey, you still pay them?
Well, you do not have to pay them, although certainly they could collect insurances through the state, either state disability insurance or paid family leave insurance, that they pay into. It doesn't cost the employer. If they are working anytime during that 6 weeks, though, because they're salaried exempt, they work any time in the week, you must pay them for the full week. So you absolutely want to cut off. No email, no phones. You are out, and we're not paying you, and you're collecting state disability or paid family leave insurance.
Okay, so something that you just said sort of prompted me to think about wage and hours, and overtime. There's all these wage and hours claims for working, overtime and not getting paid for overtime and things like that. And the one that kind of comes to mind that I have a feeling crops up in businesses, I guess I want to get validation on this, is people that are sort of working on their cell phone, maybe doing some emailing at night or something like that. Hey, I just put in, I returned 3 emails. It took me 5 minutes. It's no big deal. I'm not going to charge, I'm not going to go bill back my employer for 2 hours of work because, I returned an email.
So if they are salaried exempt employees, it doesn't matter.
Okay.
They get paid the same regardless. And so that's an easy one. When you have non-exempt or hourly employees doing that, there have been some recent court decisions that are very specific that any what they call de minimis time,
I hope we don't have any
amount of time-
employees listening to this out there. These are just employers listening to this thing, right? Because we don't want anybody cropping up with a new claim here. We're not trying to advise the employee.
But any of that time certainly is compensable time. And the way the federal law lists it is any work time suffered or permitted must be paid.
Wow.
So there was a big case with Starbucks recently where, Starbucks closes at the end of the day, but there's still time to turn on the alarm. This guy was, I think, walking employees to the parking lot and coming back and shutting down, but he'd already clocked out. And so it turned out, it was probably 3 to 8 minutes. And over time he said, look, I should have been paid for that time. And eventually the court said, yes, you should have. So you want to be really careful about people checking out, doing other things that are work related after they've clocked out.
Right. So, and you should keep track of them clocking in and out. I guess electronically, if nothing else, because you need to document when they clock in and out for these reasons. You can't just go, well, I just kind of run in the 8 o'clock to 5 and, sometimes give and take a little bit here and there.
Well, when we do HR practices reviews, it's one of the things we look at is how are time records kept? Because the state law requires that the hourly, again, the non-exempt employee must have time in, time out for meal periods and back in, and time out. And those specific, so occasionally I'll see time records that say 8 hours, 8 hours, 8 hours, and that won't fly.
those on-duty meal periods and all that. Okay, I'm not going to dive into that because it's frustrating to think about how cumbersome it is to comply with lunch breaks and all that kind of stuff. I don't know what happened to the days where, hey, show up, work hard, and at some point you'll take a break if there's time. We had, the phone's ringing off the hook. You got all these things happen, and there's a line at the counter, and it's time for my break. I've seen that in the restaurant industry. The server comes up to you and they want to, hey, I'm going on my 10-minute break. Well, okay, you want me to tip the same person? Tip the new player. Who gets the tip?
Yeah, big decision, court decision now, probably about 5 or 6 years ago, called the Brinker decision on when people have to take their meal breaks and their rest breaks. And it's really frustrating in the food service industry. And the law says they must start that meal break by the end of the 5th hour. So by 4 hours and 59 minutes, they have to start that meal break. And people are going, I just want to help my customers. I just want to finish this. So, and there are, additional time to be paid as a result of people missing those.
Okay, so I have to switch gears to keep Brian happy with me here. I could go down rabbit holes right and left. But, okay, so one of the things that he wanted to bring up was sexual harassment. I don't know why, but I said, okay, I will bring up harassment issues with Kim, Brian. Are there ABCs for sexual harassment that we have to think about? The ABCs of don't sexually harass people?
Don't do it. Don't think about it. Don't get caught if you do it. So, the state law has really, really evolved. There are now, as of this year, requirements. If you have 5 or more employees or contractors, you must do at least 1 hour of harassment prevention training every 2 years. So that's
Is that for supervisors or for the entire team?
That's for all employees.
Okay.
If they are supervisors or managers, they must have 2 hours of training. Now, that's been the case for employers with 50 or more employees for a long time, but now it's 5 or more. So in essence, it's everybody.
Do you see people, you and I were talking before the show about people that take training more seriously and more businesslike, but when you get into a subject like harassment and all the different, well, if I did this, would it be that? It's fun to giggle and joke about if you're a sophomore type individual like myself. So you sort of want to goof around, or when you start talking about these more sensitive issues, because it's easier to deal with it, I guess, on a fun level than, okay, let's talk about the seriousness of this. And so we tend to, I have to imagine you see people that are really causing themselves real issues during the training time because some of their employees are not taking it seriously, and that's actually offensive.
Yeah, quite frankly, as a supervisor or manager, you cannot let your guard down now in the workplace. Or if you're with employees outside of work, you're taking a big risk. And I hope I don't offend you by saying this, but we do a ton of what we call respect in the workplace training, what the state requires. And, when the manager says, and here's Kim, and she's doing the training, and she's going to tell us today whether harass is 1 word or 2. I start out saying, that is not appropriate. You are setting a tone. You're setting
now I'm offended.
The culture, right? So you're immediately saying to people, we can joke around about this. And I will tell you, our Respect in the Workplace classes, I think, are fun, and we do have some giggles along the way. But we also are really upfront with people of, here are the risks, here are the expectations, and you need to know what the consequences are. Okay,
so that's part of your business is helping people with their training, doing the training for them, and so on. Your main business, is that the main part of your business is sort of coming in and doing the training? Because I know you also have something I'll call a subscription where we sort of pay you to make sure that we're kind of generally compliant and have you almost on retainer. Is that...
So 70% of our business is clients on retainer. Okay. My job is to keep them out of court because we're not attorneys. We can't represent them. And we're pretty darn good at that. And so we make sure that they're schooled up, they're tooled up with what the requirements are and how to, manage around many of the laws or manage within them. The rest of our business are in things that are either management skills training. We do a lot of that. In fact, I just came back last week from Strengths Finder, Train the Trainer. I'm really excited about that. We do lots of team building sorts of things and just helping people either understand employment law or understand how to communicate better and be more respectful in the workplace. And this year, particularly because of the new law, much of our revenue on the training side has been in doing respect in the workplace training for lots of people. And we do webinars and we do face-to-face training. And, the state mandates a whole lot of what has to be covered in these now. We just find a creative way to cover what the state does.
It's interesting to think about when to bring on an HR director, how skilled they should be at what level of your company. Because if you are an early stage company, let's say you got 10 employees, to have a professional HR director who really does understand the laws and is very resourceful, a lot of times that doesn't fit into the budget, right? Because you're 10, 15 employees, you're barely over the survivability hump. And so, you sort of have maybe the office manager or maybe you're, as the owner of the company, you're sort of handling that themselves. So that's it's interesting to think about when to bring on the person who's got is it a CPP? Is that certified personnel?
It could be. There's HR, SHRM.
Okay, there's all these certifications that are the gurus or whatever. It shows that you know what your HR, you know human resources. But no, most of the time you're not doing that, right? So you're sort of like cutting that corner as well. And then, so when do you come in? Is that something, it's like 5 employees, 10, 20, 50?
We would typically come in somewhere between 10 and 20 employees. Okay. And, we're the outsourced HR departments. We're the backup for the management team.
Okay.
There are some people who will come in and actually be the HR person, and they'll come in once a week and listen to people bring their complaints or do payroll or whatever. But in those early stages, it's usually there's somebody who's wearing that hat along with other hats, and we're teaching them how to do that, and we're helping them with some of that. By the time you get, and part of this depends on your turnover, but by the time you get to about 75 to 100 employees, you probably need a full-time HR person there. You need them because you're recruiting a lot, because you're growing, because you have lots of turnover in the management team, and that gives you some risk. So you've got health insurance now you got to manage and those sorts of things. So as you grow, but typically at the early stages you don't even need a part-time HR manager.
But your business, you even companies with several employees, you still are advisory help for them as well. So they still need that help on staying up to speed and maybe even that sounding board at some level. Okay.
Yes.
Yeah. So you have companies like, I think our group of companies we've got different ones that are 50 employees, 30 employees. We have a bunch of companies, and I know you. So far, we haven't been sued. I'll knock on wood here. So keep me out of court. Thank you, Kim. Okay, so the other thing Brian wanted me to talk to you about is, in this, we're entering a climate, or we are in a climate of low unemployment. It's hard to hire good people. So I guess the hiring, firing, and retention piece of the employment effort. Any thoughts on that?
I think it's so hard to find people. I won't even say good people now. Just finding warm people is really a challenge. The unemployment rate's below 4%. And so if I'm recruiting and I think that posting a job on Indeed or Craigslist or Monster or whatever is going to get it, I'm only getting people who are looking for a job. And there aren't many people looking for a job these days. So,
right.
So that becomes a real challenge to find good people. I love, and we've done this for years, bounty employee referral programs. You put a big carrot out there for your employees to help you recruit coworkers and get their attention with that. And it's amazing. You've just hired a whole slew of new recruiters who are talking to their friends who aren't necessarily looking for a job. I think it's really important to be out networking in industry organizations and handing out your card and watching people who are really good at customer service. And if that's your business, you want to get to know them and them to know you.
Yeah, interesting. So I'm on the advisory board of something called Culture Lab X. It's all around, building an employee culture. And if the culture is strong enough, it sort of it gets known, right? It
Yes.
sort of can be almost infectious, and the word gets known that, oh, that's a pretty cool place to work. So thinking about that, are people using? What about the strategy of just paying more? Is that working?
Well, it's interesting because paying more does pay off in the short term. I mean, people have to earn enough to pay the light bill, right? And to have some place to live. So if I'm trying to pay people at a subpar wage, I won't even say minimum wage, but subpar for what that skill set calls for, they're not going to last very long. They can walk across the street at lunchtime, talk to a competitor, and what we call ghosting, and not show back up. So it's really an applicant's market right now. It's an employee's market, and they walk away.
Okay, ghosting. That's when you break up and you never communicate on that. What is? I've heard the term, but let's dive into that a little bit. Where did that term come from?
Well, somebody told me that it came from a girlfriend-boyfriend breaking up, and then, she just blocks his number. And
No, not even a Dear John letter.
No,
it's
no.
the sayonara with no goodbye. Huh?
Yes.
Okay, so people break up. So that we're seeing that. Okay, I haven't really seen that happen, but you're seeing people just not show back up to work, and you're like, hey, whatever happened to that person? You have to go track them down. I guess you got to go on your own little research mission to make sure they didn't die.
Right, and that happens not only once they're employed, but it happens way more when they're going for the job interview. In fact, I talked to a client this week who said 9 out of 10 of our applicants don't show for the interview. And I said, seriously, 90%? And she said, these are minimum wage jobs. It's not a very fun job. And so we can't even give them a sales pitch that will get them to come in the door.
Yeah.
And so they're ghosting.
It's an interesting thing because you think about technology, and it's I think because of artificial intelligence and all this technology, it's really making things more automated. So we're not really seeing inflation, but then I have to imagine wage inflation's got to be right around the corner unless we have another economic dip.
Well, I certainly think the California minimum wage going up every year will help with the wage inflation. And it's not just, this year the minimum wage goes from $12 or $13, depending on the size of the company. And when we get to $15 an hour in a couple of years, then after that, the minimum wage will continue to rise because it'll be based on something like the CPI here. So it will continue to go up. And as a result, that not only affects the people at the bottom, but it affects the people in the middle who say, hey, these bottom people keep getting closer and closer. You need to raise me up to recognize my skill and experience. And then the other piece is, and those are all for hourly employees, for exempt employees in California, they have to earn at least 2 times the state minimum wage for a full-time employee in order to meet the salary test to be exempt. So by the time we get to $15 an hour, the minimum wage for an exempt employee in this state will be over $60,000 a year. Right now it's 49 or something. So, that just keeps going up. So, the rising tide lifts all boats. Well,
Wow.
it's definitely lifting.
Interesting. Yeah, there are people that I've seen this happen where minimum wage goes up, let's say by $1, and they raise the supervisor's wage. They don't raise it, or they raise it by 50 cents, right? They don't.
Right.
They sort of try to make up for it somewhere, and it ends up being maybe somebody who's a clerk too, or a supervisor that ends up sort of eating the profit a little bit.
Yeah, and I see the biggest hit on that, well, in a couple places. One is in food service, because, food servers, although they're tipped, still in California have to be paid minimum wage. And by the way, there are now well over 20 cities in California that have a higher minimum wage than what the state minimum wage is. So I've got to be careful. If I have people working in Emeryville or Santa Clara, those minimum wages are different than what we have statewide. So I certainly see it in food service. And, I had a client say to me recently, is a really popular restaurant in the area, and he said, when the minimum wage goes up again, I have to lay people off. I can't afford what it will cost me in additional taxes, as well FICA match, as well as insurances and that, and paid sick leave and that. And then the other place I see it is, we have big organizations like Amazon come into the market, and Amazon pays above market rates, above minimum wage for
a buck or
warehouse
two above
positions.
the hourly rate. Yeah.
And so my clients who have low-end manufacturing jobs, not low-end, but low-skilled manufacturing jobs, are saying, we can't, what we used to pay as minimum wage, we have to pay above that to compete with Amazon, because Amazon brings in rich benefits as well as higher pay. And for people at that level, it's all about the pay.
Right. I guess that's where we have to think about our business model a little bit. If you're in a distribution type of business with lower margins, and that the difference is every dollar counts on an employee. You need to put yourself into a business that's maybe a higher margin type of offering, so that you can afford to the give and take of a little wage inflation is not gonna kill me.
Yeah, and I think the other thing that makes it difficult for us to compete here, which I can do nothing about, is the daily overtime. So there are 4 states left. I don't know that there were ever any more that have daily overtime after 8 hours. And, when everybody else can leverage that, work 12 hours today and you'll come back and work 6 the next 2 days, we don't have that option. We're into time and a half really quickly. 8 hours and 5 minutes, we're into overtime. So it's harder for us to compete.
Aren't there certain occupations or ways of structuring your business where you can do 410s or something like that?
You can create an alternative work schedule. It is difficult to do, and you have to have a secret ballot election, and you have to have 2/3 of the employees vote for that, and you have to keep the state notified of that. But yes, you can do that.
Okay, but it sounds like a hassle.
It's a hassle.
Okay, I'm not going to do it. Okay, so finding talent, retaining talent. We talked a little bit about culture, but sometimes we have to let people go, right? We have to fire an employee. And I know having talked to so many entrepreneurs and seeing the way they hire and they fire. So there's hiring practices that are important in terms of staying compliant and lawful. And then there are firing practices that I see people making mistakes on those all the time. Can you talk about the common ones that you see?
I think probably the biggest challenge in firing somebody is the old Holiday Inn slogan, the best surprise is no surprise. So when somebody gets either a bad performance appraisal, they get written up, they get fired for performance, that should not be a surprise to them. It shouldn't be the first time they've heard that, oh, really? You don't like my performance? So I think that's the biggest risk. Now, certainly there are other risks in terms of, are they paid on time? There are state laws that are very specific, and waiting until the next payday to pay somebody out is really risky. You can end up paying a lot of money and waiting time penalties for that. And I think the other thing, and certainly as my company grew, I realized this more and more. When you're small, people carry their own cell phones. They've got their own personal phone numbers. They've got their own computers. They're just doing that. And as you get bigger, you start to realize, if this person walked out tomorrow, who would my clients be calling? And what email address would they be using? And where are all those emails and those documents kept? Are they on my company, or are they on that employee's personal business? So part of that's just the maturation process of a business of saying, we got to pay for phones. We need computers. We need equipment that we own,
right?
Rather than asking employees to use.
So when you see that happen, you see somebody where everybody's using their personal cell phone, and they're using it for business use as well. What's your reaction?
Really risky.
Okay.
If you're the owner and you're going to be there forever, that's one thing. But you have employees, it's an at-will state, and people can leave at any time or ghost. And so you take a big risk of losing all that data.
But in terms of non-compete and things like that's a lot of people's risk is, okay, they're going to take some company information. Hey, I've got my policy down. You can't take my... you can't take any protected information. It's all written out. But invariably, people do take that information, and it's sort of tough to fight, especially for those little nuances that they took some of my customer data with them. When do people decide to fight those as employers?
Well, certainly, non-competes are not legal in California unless you're an owner. But for employees, you can't require
Just not
people to do
enforceable.
that.
And if you put that in your agreement, is there what if you put that in your agreement and it's not lawful? Is that you have problems with that? If someone
Yeah,
tries to put a
you're out of
non-compete in their employee agreement, you can't say that?
No, you can't waive your rights. So, I find that when people are looking at, you took our data. One of the big pieces is certainly you can have trade secrets and you can have confidential information. But, if one of your trade secrets is, this is our secret sauce, or this is how the formulas we use, or our confidential information is our list of clients, but you have on your website the logos of many of your clients, that is not a secret. And so it is really, really difficult to justify that.
Well, we were talking about that the other day, and I've actually dealt with this kind of thing in my own world, is people that actually have equity in a company. You give somebody ownership, and in that transfer agreement, in the event that there's a breakup, right, you can put language in there that actually is sort of non-compete type language, but that's only if somebody's an equity partner. And is that enforceable in California?
Yes.
Okay.
So, to my knowledge,
Okay.
yeah. If they own some piece, then you can get into the non-compete. But
Okay.
employee, no.
Strictly employee, no. Okay, one of the things to consider when you're really thinking about locking in one of your great teammates is maybe there's a case for giving equity. Not only does it make it more sticky, they share in the upside on an official basis, but it can be more sticky too in terms of protecting your customer list and so on. Okay, interesting stuff. Closing thoughts. We're almost out of time. I just want to get closing thoughts for employers, I guess, of all sizes. I mean, as they approach this super regulated state set of regulations that are here in California. Any kind of like words of overarching wisdom?
I think my advice to employers, regardless of their size, is know enough to know when you should call an expert. Have a little bit of knowledge to say, gosh, I should be thinking out loud with somebody who loves to do this, and just making sure that at least I know what I'm getting into. If you followed every single employment law in this state, well, you wouldn't do any business because you'd be out of business probably. But, we pick the big ones. We focus on that. Wage and hour is at the top of the list. The Me Too movement has really, really put a big spotlight on harassment, and not just sexual harassment, but all kinds of protected class discrimination or harassment. Arbitration was a big topic for Governor Newsom this year. And so you want to make sure your arbitration agreements, if you have them, are in sync, because that all changes on January 1st. So just, have a source where you can get this much information and then do a deep dive if you need it.
Know what you don't know. I guess that's important in all areas of life and in entrepreneurship. Know what you don't know and be resourceful. And getting the right people to advise you, not somebody who really doesn't know what they're talking about. They know half of the scoop. Go with a true professional, especially when you're dealing with things of this kind of importance. Kim Silvers, thank you very much for joining us. Thank you for helping the entrepreneurial community.
Good to see you, Mark.
You too. Thanks for watching today's show. My goal for every episode is that you find a takeaway, something tangible you can use in your business today. And if you have a comment about a favorite takeaway, feel free to put it in the box below. And if you have a topic that you'd like me to bring up on the show, don't forget to let me know. And also, don't forget to subscribe to our YouTube channel if you want to learn more about entrepreneurship. Because at Haney Biz, we are always by your side.